It's Anne from the Car Association. I want to welcome you and thank you for joining us today. We have Len Bellavia, Esquire, is founding partner of Bellavia Blatt, PC, nationally recognized authority in the field of automotive dealership law of all aspects. He's over 35 years experience. He's regarded as an industry expert. Mr. Bellavia, he represents thousands of automobile dealerships across the country. And again, he does touch in all aspects of dealership business, including not limited to succession and estate planning, which we're going over today, commercial litigation, buy-sell transactions. We're very lucky to have him and his associate, Toby Miller, presenting this important topic to you today. So without further ado, I'll turn it over to Attorney Len Bellavia. Len.
Okay, thank you, Anne. Appreciate it very much, the opportunity to speak to your members. I'm Len Bellavia from Bellavia Blatt. Pleased to have Toby with us today. Talbott Miller, we know him affectionately as Toby. Toby is one of the leading authorities on estate planning. I mean, his credentials go on and on. We're not going to spend a great deal of time. I think it would take the entire webinar to go through his stature as an estate planning expert. We, as many of you know, we do a lot of automotive franchise law related to operational issues concerning auto dealers. In particular, over the past, I'd say 18 months, suddenly our dealership succession and estate planning practice group has gotten extraordinarily busy. I think it's a combination of COVID kind of reminding us of our mortality. The average age of dealer principals and dealer owners has gotten to the point where people are necessarily thinking about the future. And then finally, the new administration has been talking rather aggressively about making some change that makes dealership estate planning and succession planning much more relevant than it ever has been. So we're going to try and go over as much of these issues. This is typically not the most exciting subject, estate planning. It kind of reminds you of, life insurance and things that you don't like to think about, but they're very important. And we're going to explain to you why it's so important in terms of how much money can be essentially paid to Uncle Sam unnecessarily. So it's important, and it's important given the time frame that we're dealing with all of these pending potential changes in the tax laws. Also, I think it's worth highlighting at the outset that dealership succession and estate planning they're two different concepts, but they necessarily must be acted upon together. I can't tell you how many cases we get in our office where a dealer will call us and say, I did my estate plan last year, and my manufacturer is giving me a hard time because I didn't notify them. Or we get an estate plan that was effectuated years ago, and the dealer passes away, and suddenly the heirs are left in a position where they're scrambling and they're racing against time because the manufacturer wasn't notified of the estate plan, and now there has not been a successorship plan put in place so that there could be a smooth transition. So this is going to be, I'd say, 7 parts estate planning and 3 parts succession planning. Most of the presentation will be given by Toby with respect to estate planning issues. Further on into the presentation, I'll be talking about the practical aspects of marrying dealership succession planning into an estate plan. Like I said, they shouldn't be done separately because, and I'll explain later, they could create problems with your manufacturer. So a lot to cover in a relatively short period of time. I know we'll be accepting questions, so type them in as you go forward, and we'll save the Q&A towards the end. So we'll leave some time for that as well. So without further ado, Toby Miller, why don't you take the lead and talk generally, and then I guess more specifically as we go about some strategies.
Thanks very much, Len. Well, if we go to slide 2, I mean, here's the basic subject for today. It's protecting your dealership business. And when I think about protecting your dealership business, I think about transitioning it to the next generation. Not that you're going to do that today, but to achieve it in a way that's economically efficient and saves your family a lot of heartache, it has to be planned for. And that's what we're going to talk about today. The agenda on page 3 is First of all, I'm going to talk a little bit about what you can do to deal with the estate tax burden that is levied when you transfer assets to the next generation. Lou will talk to you about preparing the next generation managers. And I'm going to talk a little bit about proposed estate tax changes that we may have to deal with. One thing I'm going to talk today about is why transfer ownership. Why would you want, could we go to the next slide, please? Why would you want to transfer ownership of something today, to place something in an irrevocable trust? Well, we have an opportunity today. We have a unified estate and gift tax system in the United States. And basically, you would pay the same tax if you transferred property during your lifetime or if you transferred it when you passed away. There is an exemption. You have an exemption of $11.7 million right now. And what that means is you can transfer assets to trust for your kids or directly to your kids or to other people. And there's no tax on the first $11.7 million of taxable gifts. Once you go over that amount, there's a 40% federal tax. If you live in Connecticut, and I assume many of you live in Connecticut, there's also a Connecticut gift tax. The Connecticut gift tax comes in at a lower level. Right, for this year, there's a $7.1 million exemption, so you have to plan for that as well. You also want to plan to avoid probate. Avoid probate doesn't involve any irrevocable actions, but it does involve reorganizing your assets a little bit. And lastly, I want to talk about creating a structured transfer to the next generation. That just means you give your children, presumably they're the next generation, you give them all the protections that you were able to give them. You're going to give them liability protections that they can't give themselves, and you take advantage of that. Let me just talk for a few minutes about the federal estate tax on the next slide. And let's see how it would operate. The current exemption, $11.7 million, is a very odd number. Why is it $11.7 million? Well, the actual statutory exemption is $10 million. At some point in the past, Congress decided that that should be adjusted by inflation. So every year it gets an inflation adjustment up, and that's how we get to $11.7 million. The exemption is scheduled to be cut in half on January 1, 2026. So we have an example here, example 1A. What if somebody had a $10 million estate and there was a $5.6 million exemption? There was a $5.6 million exemption, then you'd have $4.4 million taxable, and you'd get a federal estate tax of $2.1 million. Also in Connecticut, you'd have an additional tax of about $500,000, so that's $2.6 million on $10 million, a very substantial tax. Now let's look at example 1B. If you had the same situation, but you had our current exemption of $11.7 million. If you had our current exemption of $11.7 million and a $10 million estate, you would have no estate tax whatsoever. You would have some Connecticut tax, again, about $500,000, but the big tax, the federal tax, would not apply with this $11.7 million exemption. Now, as I said, this exemption is going to be cut in half under current law, effective January 1, 2026. Right now, Congress is writing some tax bills that'll be effective at some point next year or the year after. And one of the things on the House's agenda is accelerating the reduction of the exemption, possibly to as soon as next year. Now let's look at example 2A. And what example 2A does is it illustrates the benefits of making a gift to an irrevocable trust. In this particular example, we assume somebody has $10 million. We assume that money is invested, and over the next 10 years, it grows to $20 million. What if they'd done no planning? If they did no planning, with this $10 million fund. There will be a basis step up on death, but there will be an estate tax, assuming the lower exemption amount of $5.6 million. That is on the 10 million plus the 10 million in growth. Now let's look at another example and see what would happen if that client had transferred that $10 million out of the estate, had put it in an irrevocable trust for the kids, or had put it in an irrevocable trust for the spouse and children. Now that $10 million is in a trust. It grows to $20 million, just as in the prior example. The individual dies. What's the tax? There's no tax. All of that growth escaped estate tax. All of that growth escaped estate tax because the individual took the step of placing the assets in an irrevocable trust 10 years before. How is this done? The next slide shows kind of the mechanics of setting up an irrevocable trust. The individual on the left is the grantor. The triangle on the right is the irrevocable trust. An irrevocable trust is simply a trust agreement that's drafted by a lawyer. It's a trust agreement that's set up and embodies your wishes. It's going to have a trustee or trustees. The trustee or trustees are responsible for investing and managing the assets, and they're responsible for making distributions to the beneficiaries. How do they decide how to make the distributions? The trust agreement, which is set up according to your wishes, is going to tell them how to make the distributions. The trust agreement might be for the benefit of your spouse and your children, and the trustees would have discretion. The trust agreement might give your spouse a very broad, limited power to say where the property goes when he or she dies. That would give you some protection that if you needed that fund to support yourself in the future, your spouse could appoint it in further trust back to you. You can create a trust and your spouse can create a trust. You can be trustee of your spouse's trust. Your spouse can be trustee of your trust. Lawyers call these trusts SLATs, for spousal lifetime access trust. They're very, very popular. We've done a lot of them in the past 10 years. What does your family get from this? Well, all the growth in the value of these assets after you make the gift is going to be out of your estate. You escape a 40% tax, or if you live in Connecticut, close to a 50% tax on the growth in the value of these assets. Well, now I'm going to shift gears a little bit and talk to you for a moment about probate. Probate is something that lawyers talk a lot about. It's simply the process of when you pass away, the lawyer and your family take the will to the probate court and sign some papers. And the objective is to have the court determine that the will is valid, that it wasn't the product of fraud, and to appoint someone to manage the estate, the person named in the will, the executor, or the personal representative. And in many states, it's very, very simple. In some states, it's not. Connecticut is one of those states where probate, I would say, is much, much more complicated than it is in many other states. If you have the misfortune to have a difficult situation, litigation, a family dispute, a dispute over a trust you created, then probate can take a very extended period of time. It will be tied up in court. I think the most distressing part of it for many people is the publicity associated with probate. You know, local papers are always looking for news on local people. And if there's a family dispute in probate court, you can bet that all the details of it are going to appear in the local gazette. It's very, very stressful, and it comes at a time when all you want to do is transition everything quickly, and it's a delay in the transition. And the next slide just shows some common images of how bad probate is. Loss of income, yeah, income can be very delayed because management of the assets is tied up in the probate court. Loss of control, it can be very difficult to take instant actions. You have to get somebody appointed as an interim administrator of the estate. So what do? What are the asset transfer solutions? Well, let's go to the next slide. When you sit down to do estate planning, most lawyers will want to do a will, and that's okay. A will transfers your property when you die, but then you have to go to probate court and you have potentially those difficulties that I mentioned. A better solution in a lot of cases is to use a revocable lifetime trust. That's simply a trust agreement, like I talked about before, but this one can be changed at any time. And with this trust agreement, you're going to be the trustee and you're going to be the beneficiary. And you're going to simply transfer your assets into the name of this trust. It takes a little doing to transfer the assets, but once you do that, the assets are in the trust. The trust is going to have continuing provisions, which you can change at any time, for what happens when you pass away. But because the assets are in the trust, you don't have any probate of those assets. They're already in the trust, and there's no delay. This could be very, very important with respect to your business assets, because your business assets, maybe you put some of them in the irrevocable trust, maybe some of them are outside. These can be in the revocable trust, so there's absolutely no delay in management of those assets. This is also going to be the vehicle where you're going to transfer a lot of the assets to your children. You're going to have a choice about whether to leave the assets directly to the children or to leave them in trust for the children. The one big thing about leaving assets in trust for anyone is that you give them liability protection. You give them protection from liability that they cannot get themselves with their own assets. If you're a beneficiary of a discretionary trust and you get sued, that trust is not going to be responsible for any judgment against you. So that's a protection you can build in for your children. Maybe you build it in for all the child gets. Maybe you just deal with the business assets. But it's a very, very important thing to consider that one of the most important things you can give your children is this liability protection from trusts. If you go to page 13, they're blended solutions. You can put assets in a limited liability company. A limited liability company has the advantage that you manage the limited liability company, but you're going to want to make sure that title to that limited liability company is in your revocable trust, or that limited liability company is going to end up in probate. So that's very, very important. You're going to want to move some assets out of your estate into a revocable trust. You're going to want to keep some assets in your estate. The way the law is currently structured, you may want to move some assets back and forth to take advantage of the step up in basis that occurs when you pass away. So that's my suggestion on how to set up your estate. Now, if I could just take a minute and talk about the state of changes to the estate tax law. When the new administration came in and made their proposals to Congress earlier this year, they proposed a very radical change in the capital gains tax, which would impose a capital gains tax at death and would impose a capital gains tax if you sold assets to an irrevocable trust. Now, the Biden administration didn't campaign on this capital gains tax, and it was met with complete lack of interest in Congress. It does not appear that capital gains proposal is going to advance. However, in looking for other ways to raise revenue, the House Committee, the House Ways and Means Committee, is looking at a proposal to move up the date of reducing the estate tax exemption, cutting it in half, moving it up as soon as next year, if they can actually get a tax bill done this year, which is somewhat in doubt. So that's the current state of legislation in Congress. I would say that while the capital gains tax is not going to go through now, you never know. It's now out into the public arena, and you never know, as the government searches for revenue, whether that may come in at some future point. Lou, I think I'll hand it back to you, and you can talk about preparing next generation family members.
Sure. If I could just interject, Toby, one of the concerns dealers have, obviously, when we talk about a trust, is that they're transferring ownership of their dealership in some cases. How would you respond to the question of, well, am I giving up control of operating my dealership in a trust context?
Well, your dealership is going to be, it's a separate entity, right? It's a company. It's an LLC, or it's some kind of company. And if you're chairman of that company or president of that company, you're still president of that company. And the trustee, no trustee is going to remove you, because no trustee is going to know better than that person how to manage that business.
Exactly. All right, we can go to the next slide. It just headlines. What I wanted to address was some of the, I guess you'd call them, showroom floor type issues that, in my experience, dealers have to consider, and they do raise as concerns whenever they're talking about a sophisticated estate plan. We can go to the common asset transfer concerns. First issue, when we become engaged in this type of a situation, if this is a family business, meaning father, daughter, father, children, whatever the relatives may be, oftentimes the senior person in the operation presumes a bit much. So we do some due diligence in terms of what the next generation is truly interested in doing, because oftentimes we find that the children of a dealer principal, while they may be operating the dealership or assisting in the operation, may not have the same long-term goals and aspirations that the dealer principal may have assumed. So oftentimes we'll sit down, and this is a necessary element of any estate plan involving a small business, but in particular, auto dealerships. Daughter and son may be there for reasons other than what the father may think. For example, we had a matter recently where the daughter was there and intended to stay there as long as dad was around, but if dad wasn't around based on disability or death, her intention was to go into a different career. So why is that important? Because these estate planning tools are designed to facilitate the long-term goals and objectives of the family. So it's necessary as a threshold issue to determine what the long-term plan is. And what I mean by that as a practical matter is oftentimes we'll sit around and say, well, look, in most cases, when the patriarch or the matriarch of the family passes away, it's time to sell the dealership. But more and more, and I'll discuss that in a moment about the procedural aspects of doing that. But more and more, we're finding that the heirs, the spouse, wants to continue. We're handling a couple of matters now where dad always wanted the grandchildren to become the heir apparent to the dealership, but they're not of age. So the question is, how do you facilitate the continued operation of the dealership, not sell it, but keep it in the family until such time as the grandchildren. Of course, that's a giant leap, right? Because you don't know if the grandchildren are even interested. So oftentimes there are interim solutions to determining whether or not the dealership should be sold upon the death of the dealer, or whether there should be a intermediate stage where you appoint an executive manager. I'm sure you've heard these terms, paragraph 3. It's a term of art in the auto industry. Paragraph 3 is the provision in most OEM franchise agreements that identifies the dealer principal. So that is akin to what we as lawyers call a personal services agreement or concept, where the manufacturer is depending upon the dealer principal in paragraph 3 to be the full-time operator of the dealership business. Now that's to be distinguished from, and you may have heard other terms like executive manager or operator. Each manufacturer has different nomenclature, but it may be appropriate if a son or a daughter is not of age, or may be operating the business but doesn't yet have sufficient experience to qualify as a quote-unquote successor. And on this slide, you see the term successor addendum. So it's necessary and it's advisable when talking about an estate plan to deal with a succession plan. And what I mean by that is a successor is where the dealer, before death or disability, tees up the individual that he or she wants to run the dealership upon his disability or his death. It doesn't naturally flow, right? Because you don't know when death is going to occur, and it may occur at a point in time where the daughter or the son is not sufficiently experienced to step in the dealer's shoes. But what you don't want to do, and in Connecticut in particular, because the window of opportunity under the Connecticut dealer statute is rather limited in terms of the amount of time that a dealership has to appoint a successor and then seek the approval from the manufacturer. So you're dealing with essentially less than 6 months of time upon the death of the dealer to propose a successor. Then the manufacturer has a couple of months, 60 days, to say yes or no. And then if the manufacturer says no, there's a very short window of 90 days within which the dealership franchise agreement could be terminated. So I'm raising these issues because I can't tell you how often dealers just assume that an estate plan involves going to an estate planning attorney and putting together all of these very important documents, but they forget that part of the process is to provide for a smooth transition upon the death. So the business is the big asset here, and you want to make sure that you're providing for the continuity of the business, even if the goal is to sell it. Because what you don't want to do is, upon the death of the dealer principal, then put the dealership up for sale, knowing that there's a very short window to do that. And closings typically, the process of putting a dealership up for sale and selling it could take 6 to 9 months. And based on the language of the Connecticut statute, that may not be enough time to do so before the manufacturer has the right to terminate the franchise agreement. So as important as it is to provide for an estate plan that Toby just talked about, at the same time, you should be discussing a successor addendum so that whether it's a child or an executive manager, there is enough time to deal with the succession of the business, whether it's to stay in the family or to sell it, such that you're not at a fire sale. Now, in this economic climate, quite honestly, there wouldn't be necessarily a fire sale because there's an overwhelming demand for dealerships. So in this climate, we probably wouldn't have to worry about a fire sale, but hopefully we're not dealing with the death of the dealer principal for a long time. So in 20 years from now, let's say, we don't know what the market is going to be like. And also, let's also remember that manufacturers can have ulterior motives. So you might find that a manufacturer is not going to be so cooperative with your proposed successor after your death. So you want to flesh out problematic issues early on. Well, there is no urgency and there is no deadline. So we can go to the next slide, which addresses some of these issues, for example, that an OEM manufacturer may want to put out there. Let's just say, for an example, that the manufacturer has a favored dealer that they would like to see acquire the dealership upon the death of the dealer principal. So now there's an ulterior motive. So when if you wait until the dealer dies and you then apply to have daughter or son become the dealer, the manufacturer can decline based upon what may be disingenuine business issues. They could say your sales performance is insufficient and it's chargeable to the daughter or chargeable to the son because they were the manager. And I can't tell you how many times we find that claimed deficiencies with respect to sales or CSI are not legitimate. They may be measuring your sales performance based upon a geography that's unrealistic or unfair to the dealer, and the law is evolving on that issue. So oftentimes the rejection of a successor, keep in mind the manufacturer is aware now they have an opportunity that they can seize upon to thwart the proposed transfer of the operation of the dealership within the family, and you don't want to be dealing with those type of issues when you have a 90-day deadline looming. Better to deal with it now, flesh it out, propose son or daughter as the successor, see what kind of response you get, and then deal with it now. So, well, there's no, first of all, generally families are in disarray when the dealer dies, just emotionally and financially. So you don't want to have to deal with it under those circumstances, plus with a deadline looming. Better to deal with these issues now. So if nothing else, I just want to get across to everyone that estate planning without succession planning is only 50% of the job. The next slide. We want to communicate to the manufacturer. We can go to slide number 17. The plan for the succession, right? We want to make sure the manufacturer is aware that a trust is being created because your dealer agreements, each of them from every manufacturer, says if there is a change of proposed ownership of the dealership, i.e. being moved into a trust, well, the manufacturer is entitled to that notice. Again, we don't want to give the manufacturer the right to claim that there is a default under the dealer franchise agreement because there was a change in ownership. And as innocuous and innocent as it may be, that you're just providing for estate planning, which every business owner should do, we don't want to unwittingly give the manufacturer the opportunity to claim that the transfer was done without consent and therefore there's a material breach of the franchise agreement. So there are some procedural aspects, not just strategic, but you just don't want to step into a default position. And if the manufacturer does decline your proposed successor, you want to challenge that now. If it is a son or daughter who is intended to be the heir of the dealership, you want to flesh it out and challenge the manufacturer now so that by the time death or disability arrives, it's seamless and you need not worry about engaging in a fight with the manufacturer at a point in time where the dealership is not in its strongest state. All right, Toby, why don't we pick it back? Hopefully we can advance the slides. We should have been on slide 17. All right, now we can move to 18. Toby, back to you.
Sure. Thanks, Len. You know, there is always a lot of uncertainty with estate tax law changes. Generally, what happens whenever there's a new president, there's in the last 20 years, there's been a tax bill in the first year or two of the administration, and that sort of sets the estate tax policy while that president stays in office. I alluded to the fact that there's a possibility that the estate tax exemption is going to be cut by half. In theory, it could be cut even further. It could be cut to $3.5 million. That was actually something that Biden had campaigned on or was in the campaign literature to reduce the estate tax exemption to that level. There's also a possibility of increasing the estate tax rate. The 40% rate, though it's high, it's been higher. It's been as high as 55%. It's been as high as 70%. So don't think the estate tax rate couldn't go up. And there is, as I said, there's the possibility of a change in law to eliminate stepped up basis. Stepped up basis is refers to the fact that when you die, the cost basis for tax purposes of everything you own, everything that's included in your estate or your revocable trust, everything is stepped up to its date of death value. Congress changed that once many years ago and then took it out of the law a few years later because the technology was such that it was impossible to track basis that somebody had for a long period of time. Now the technology is there, and we've seen the Biden administration at least put it out there. It certainly is a possibility for the future that that could come into effect. Len?
Okay. All right. So what I would recommend is if anyone has questions, please text them to us in the chat room field at the bottom of your screen, and we'll be happy to answer them. Could we move the slide, Carly, to number 19? There's a couple of questions so far asking whether we can provide this slide deck, and the answer is yes. Please email us. You'll see our email at the bottom there, info@dealerlaw.com, and we'll be happy to get the slide deck out to anybody who's interested. Let me just click and see if we have any questions. All right, so there are no questions so far, so I'm going to keep watching. I'm going to give an example of one estate plan we worked on recently, which there was an unexpected death of the dealer principal, met with the spouse, talked about sale of the dealership, blue sky values at the time of that were still very high, so explained to the widow what the options were. Widow decided she wanted to continue keeping the dealership in the family. So the task was to, and didn't have a son or a daughter in the business. So our agenda was, and we had to do this within the confines of the deadline, that some states have longer periods of time. In New York, for example, upon the death of the dealer principal, there's an 18-month safe harbor for the dealership to deal with the succession, so that the manufacturer cannot squeeze out the dealership under threat of termination and force a sale. So what we did was we did a national search for a general manager, an experienced general manager that we could bring in as an executive manager. So we'd have to apply for factory approval. So think about the process. We had this was a position that we had to really take very seriously. This wasn't just an interim general manager. This was a person whose role was going to be to provide stability to the dealership in a time where the leader is no longer there, keep the dealership employees. This is another very important consideration, because obviously upon the death of the dealer, there's uncertainty and instability amongst the employees. So we had to find somebody, take the care to make sure it was qualified, but move it along as quickly as possible so key people wouldn't leave the dealership. So it's more of an art than a science, but the point is you have to move quickly. But procedurally, what we did was we were successful. I mean, it was an arduous process, because we weren't looking in the local area, because we didn't want to look in the local area, because we didn't want the word to get out. So we were doing a lot of flying around, bringing people in, interviewing, identifying the compatibility of the business plan with the widow, and then engaging in a compensation agreement that fairly recognized the value that the general manager was bringing in, but not providing all of the control of the business to essentially a stranger. So these are all examples of why early succession planning is important, because although it worked out very well in that example, it could have been a disaster had we not been able to find the right person within the window of time that the state statute gave us. So again, this just goes to the issue of doing estate planning at the same time you do succession planning, because the value of the dealership depends on the continued smooth running of the dealership, even if it's only a 6-month period of time. I used the term earlier, fire sale, and I don't want to give the wrong impression. It's a rare case that a dealership gets sold in a manner that fetches less than the fair market value. And why is that? Because as long as there's more than one interested buyer, it's going to drive up the price. And over the course of our practice over 35 years, I can't tell you how many times, especially in bad times, 12 years ago, where dealerships filed Chapter 11 and the sales had to happen in the bankruptcy court context. Even then, when you would presume that the value is going to be deflated as long as you have multiple people showing up to bid on the dealership. Keep in mind, a franchise mark has intrinsic value unrelated to the operation and the profitability of the dealership. There are so many factors. So although I mentioned, a distress sale or a fire sale, I don't want to unintentionally scare people into thinking that if they don't do this now, they're going to wind up getting 10% of what the dealership is worth. I mean, it could happen. It's more emotional than anything else. I think you want to make sure that you line up all your ducks and make sure they're taken care of, if for no other reason than not to put your family in a very stressful situation. So it may still have a valuation. Like I said, if it happened in this climate and there was an estate sale, you probably wouldn't lose any value because there are more buyers than sellers. But obviously we want the dealers to live long lives, and maybe this will happen in 30 years, and we can't predict what the economy will be like at that time. All right, let me see if we have any other questions. Toby, here's a question for you. Why would someone use an irrevocable trust over a revocable trust?
Sure. Well, they're for different things. You use an irrevocable trust when you want to give something away. It's going to be the vehicle to make a gift. So you can give property directly to your children, or you can use a trust. You can use an irrevocable trust, which means you can never amend it, and you can never get the property back. And that way you can tailor how the gift is handled. You can put in trust provisions which keep it out of the hands of the beneficiary and provide for professional management. A revocable trust is something you use as kind of a will substitute. You're going to put your assets in this revocable trust, which means changing the title on your bank account. You have a securities account, you're going to change the title. The business or LLC, you're going to change the title from your name to a revocable trust in your name. You're the sole trustee. You can change the trust at any time. It's just a different way to hold property, which for all intents and purposes, legally and tax-wise, it's the same as yourself. This revocable trust will substitute for your will when you pass away, in that it'll become irrevocable at that point, and it will contain all of the provisions for your spouse and your children.
Okay. Toby, another question. What is the difference between using a trust versus an LLC?
Yeah, an LLC is a vehicle for managing assets and for, in a strategic estate planning transaction, trying to get a discount in the value of assets. The theory is that if you have assets that you own directly and you give them away, someone can manage those assets directly. If you have assets in an LLC and you give interest in that LLC away, well, there's a manager of that LLC. You just have a percentage of it, and it's worth less than the underlying assets themselves. An LLC doesn't operate to transfer ownership. A trust operates to transfer ownership. So the LLC would be owned by the trust. Would there be an identity between the manager of the LLC and the trustee? Maybe, maybe not. It would depend on the specific circumstances and the objectives, and we discuss all that as part of the estate planning process.
Okay. Next question. Please review how to get this process started. It's a preliminary meeting necessary in person. In this day and age, we can certainly do a Zoom meeting preliminarily. We would ask, obviously, for a summary of the assets, real estate, business, personal, the family structure. So you don't have to come, running in here initially. We can certainly deal with the preliminary issues by phone or Zoom meeting. And then, yes, ultimately, what I normally do is go visit the dealership. And then once we start in earnest, If there are family members, we'll meet with the family members separately so we can identify some of the issues I mentioned earlier about the long-term goals and objectives of the younger generation, the second generation or third generation. Bring that back to the dealer principal. You know, we've handled cases where there are 4 or 5 children, you know, nephews, nieces running a large family business, and that requires a lot of fleshing out of before you even put pen to paper, you know, drafting any of these documents, identifying what the long-term picture looks like. So this is not a one and done type situation. Toby, maybe you want to speak more generally about what your typical intake looks like when you're meeting a business owner for the first time.
Yeah, obviously this is an important thing for you, and what I do is have a meeting, and we get to know each other, and we decide on a course of action. I don't charge for an initial meeting because it's just I'm not going to charge you unless we decide to go forward and do something. So the initial meeting, as you say, hopefully we get the information on the assets and the family members, and then I'll go through some Q&A with you to try and figure out what kind of plan you want, and we'll try to make some decisions, tentative decisions, and then if you decide to go ahead, I'll follow that up with a letter or a memorandum that says what you think you want to do, so you have another look at it and can think about it again, and then we put the shoulder to the wheel and do it.
Toby, can I throw out just a hypothetical, because I know we get this often. Dad may say, you know, daughter is the general manager running the business, but I have 2 sons who are not in the business. How do I distribute my estate in such a way where I can provide some parity, some equity, so none of my children that are not operating the business feel like they're not getting slighted?
Boy, that's really the $64 question. That is, when I was talking about the difficulties of probate, that's a case where you have difficulties with probate. And it's an issue that really has to be addressed carefully, because you want to make sure that all the children feel like they're treated fairly, so they don't try to blow up what you did after you pass away. And it can be a very, very difficult issue, because you're dealing with a closely held business today, and it's hard to value a closely held business. It's not, you know, it's not 100 shares or 1,000 shares of Apple. It's a business that, you know, the fortunes may ebb and flow, and what you do today to equalize it may look different when you pass away. The business may look a lot better, and the person may feel slighted. So it's important to try to build in some flexibility to make up for what you thought was right but didn't turn out to be right. But it's a very, very difficult issue.
A related question, Toby, just came in. What are your thoughts on issuing non-voting stock in an S corporation to the children of the dealer?
Well, what you're talking about is splitting ownership and management responsibility. And I think that's obviously, now you're getting into really your issues, Len. You're talking about how do you transition ownership? How do you get the children involved in the business? There's a legal way and a tax way to do it, and that's easily done. Off the top of my head, I don't know if it works with an S corp, but if it didn't work with an S corp, we'd find another way to do it. An S corp can only have one class of stock, but there is a way to achieve it. The underlying issue, though, is more transitioning the children into the business.
Okay. All right. I know we're coming toward the end of this session here. I should have put my phone number on this slide, but for those of you who would rather call, it's 516-873-3000. But you could email. We get those emails. Hopefully I'll be seeing many of you in a couple of weeks at the CARA 100th anniversary in Newport. We're a sponsor of that event. Happy to do so, and hope to meet many of you there. in the meantime, if we haven't addressed any of your questions, or if you have other ones, just shoot an email. We will get back to you quickly. And wanted to thank you for your time. I know this is not the most exciting issue, but quite honestly, it's very topical, and it's something that I think every dealer should pay attention to now that we're on the precipice of having some potential new tax changes. So it really requires some focus now. All right, thank you very much to Ann and the association for having us. And like I said, we're here if you need to ask us any further questions. Look forward to seeing you all soon. Thank you.
Thank you.